Congratulations on your new judicial position. Whether you're being a judge is a new role or you are ascending from a lower bench. I want to welcome you to the King County Superior Court and the best job in the world. So I'm going to be spending a bit of time with you to discuss ethics and the code of judicial conduct. Unlike the other areas of judgecraft, you will learn, you will be using this information every day for the rest of your new judicial life. So, the Code of Judicial Conduct is what gives guidance to all judges on judicial ethics. What we're going to review is what is the code, what's its history, and what is its purpose. The purpose of the code is to establish the basic standards of ethical conduct for judges. It's the floor. It's the minimum expected of judges, much as the rules of professional conduct is the minimum or floor expected for attorneys. It governs the conduct of you as a judge. It ensures that there is public trust in our conduct as judicial officers, ensuring that we are fair and promote public confidence. The code is organized into canons, which are the overarching principles, rules, which form the disciplinary bases, and comments, which provide guidelines and examples of what you can do and not do. The canons state the overarching principles of judicial conduct that all judges must observe. They provide important guidance in interpreting the rules. A judge may be disciplined only for violating a rule. In the preamble, it states what the purpose of the code is, and it is to provide confidence in the judiciary, not in individual judges, but in the bench as a whole. Disrepute to an individual judge brings disrepute to the entire bench. The first canon provides guidance through what we call the 3 I's. I's are independence, integrity, and impartiality. Please note that each of these terms is given an asterisk or a star in the code. That means that these terms are individually defined in the code. This is the 24/7 rule. It's similar to that which is provided under the rules of professional conduct, but is even stricter and more enhanced for judges. Judges can be sanctioned for on-the-bench conduct as well as off-the-bench conduct. Remember, you are judged 24 hours a day, 7 days a week, 365 days a year, and your conduct must reflect that at all times. So this is an interesting rule. 1.1 says that judges must comply with the law, including the Code of Judicial Conduct. This actually has 2 meanings. One is application of the law from the bench, and the second is complying with the law in all aspects of your life. So for example, while you're on the bench, you must apply the law as you interpret it, whether it be a statute, a code, or a rule, or any other interpretation of the law. Generally speaking, a misinterpretation or misapplication of the law or error of the law is not sanctionable under the Code of Judicial Conduct. There are some exceptions to this, such as a deprivation of a civil liberty or basic fundamental right. If a judge abuses his or her contempt power, which is an error of law, that could subject the judge to a discipline under the code. Off-the-bench conduct means, for example, if you engage in criminal activity unrelated to your role as a judge, you can still be disciplined under the code. And obviously, this is because you erode the public confidence in your ability to sit as a judge when you violate the law, particularly in your personal conduct as well as in your professional conduct. So impropriety has 2 provisions. One is an actual impropriety. That would be, for example, if a judge were to swear in the courtroom or to engage in other types of obvious misconduct. An appearance of impropriety is whether there is a perception that the judge is acting in an improper fashion. The example I like to give is as follows. If a judge is having a new case in his or her courtroom and the plaintiff's attorney shows up first, the attorney goes back to judge's chambers and the judge asks him about the case. They start discussing the case. That is an actual impropriety. That is unauthorized ex parte contact with the court discussing the case. Now, same example. Plaintiff's counsel shows up first, goes back to judge's chambers, and all they discuss is the Mariners or the Seahawks or the Sounders. And then the plaintiff's attorney, along with the judge, come out and the case is about ready to get started. They're ready for trial. There's defense counsel along with his client. Judge comes out with plaintiff's counsel. Judge hasn't actually done anything improper, but how do you think defense counsel and his or her client is going to feel when they see that? That would be an appearance of impropriety, even though the judge did not directly act improperly. 1.3 is avoiding the abuse of the prestige of judicial office. Basically, that's using your status as a judge to gain some type of personal or economic advantage for yourself or for others. An example of this is shown that is allowed, which is you can provide a reference or recommendation for an individual based upon your personal knowledge of that individual. This used to be an ethics advisory opinion that's now been codified into the new code as of 2011. Even though you're giving a recommendation or a reference, you cannot use your office to improperly try to influence a third party into giving a benefit to another person. A judge can't use your position for any type of personal advantage or deferential treatment. For example, if you were, unfortunately, to be stopped by a law enforcement officer, allegedly while you're speeding, you cannot use that to your advantage by saying, "Can you give me a break? I'm a judge," or "Don't I know you from my courtroom," or something along those lines. Another example would be using your judicial letterhead. If you happen to own property and you're a landlord, you cannot write to your tenant on your official stationery saying, "Oh, by the way, your rent is late." That would be an improper use. One thing you can do, for example, would not be abuse of the prestige of your office, is if you are going through a security line and they have special arrangements for judges for security purposes to get you to the front of the line or to have you enter in a different entrance. That is not abuse of the prestige of your office. Canon 2 provides that you must perform your duties impartially, competently, and diligently. You must do so with impartiality and fairness to all. Again, as I noted earlier, you have an obligation under the canons to uphold and apply the law. However, good faith errors of fact or law generally do not violate the rule. So judges are allowed under the rules to make reasonable accommodations to pro se litigants. However, that does not allow judges to rise to the level of advocating on behalf of a pro se litigant. If you look at the case of Edwards versus LeDuc, which is at 157, Washat 455, the Court of Appeals notes that a judge must always remain impartial. So you may assist pro se litigants in terms of helping them procedurally and understanding what the rules are, but you cannot advocate on their behalf. Without saying, judges must be impartial, which means that they cannot show bias or prejudice toward any parties or persons, and this includes using demeaning language, behavior, humor, stereotyping. Please keep in mind that we bring into the courtroom our own implicit biases, and try to make a check on this, even though it sometimes can be very challenging and difficult to do. Decorum and demeanor are the number one complaint that judges get before the Commission on Judicial Conduct. You are required to maintain not only your own demeanor, but also to ensure that others in your courtroom respect the courtroom and that there's a certain level of decorum. You'll sometimes have to handle outbursts in the courtroom or improprieties on the behalf of witnesses or litigants, and you're the one who is responsible for ensuring that everyone in your courtroom respects the decorum in your courtroom. Ex parte communication, this proscribes that you cannot have contact with persons, attorneys, or others regarding the substance of a pending matter in your courtroom. The exception to this is other judges with whom you can discuss the case unless that judge is recused. There are a number of potential sources of ex parte communication that you will be exposed to on a regular basis. And this can include the jail, the Department of Corrections, parties including love letters from Walla Walla, parties' families, various interest groups. You will sometimes receive unsolicited email, and if you are on Facebook or other social media, you could have ex parte contact inadvertently with these individuals. If you do inadvertently receive ex parte communications from any of those listed as indicated, the rules require that you shall promptly notify the parties, and this includes ex parte communications with your staff, your lower bench. You must let individuals know if there's a substantive communication about this case. It does not involve administrative matters such as simply setting a hearing. Ex parte communications includes a proscription against ex parte investigation. What that means is, as a judge, whether you're the fact finder or the jury's the fact finder, you cannot investigate facts just as a juror cannot investigate facts. This includes electronic communications. So, for example, if there's a request for a bond in an injunctive case, you cannot look up on your computer what the net worth of a company is in deciding how much of a bond to set for an injunction if you are going to grant that. You can ask the parties or the attorneys to provide you with that information, or you can request that the attorneys authorize you to look up that information. However, you on your own cannot look up that information without disclosure and buy-in by counsel or the parties. There are some exceptions to the ex parte prohibitions. Those include scheduling matters, emergency matters, administrative matters, which don't address the substantive issues in a case. And also, if there are statutory exceptions or policy exceptions, such as those related to a mental health court, drug court, or other therapeutic court, provided that there's no party that will gain advantage through that ex parte communication and the parties are promptly notified of that communication. A judge can have ex parte communications for purposes of settlement discussions. So under that scenario, you're going to be talking to one set of litigants about offers and negotiations of settlement, and then go to the other parties or counsel to discuss the same. That is expressly provided for under the rules. We're now going to talk about disqualification or recusal of judges. This is a relatively new rule, which is Rule 2.7, and that is that there is an affirmative duty for judges to decide and hear cases, even those that might be controversial or difficult for judges to hear. This duty to decide includes those types of cases that might bring public disfavor to either the court or to the judge. Personally, you cannot decide, I don't want to hear this case because it's too difficult or too controversial. Remember, when you recuse, just because you think that the case is too controversial or is going to bring too much disfavor upon you personally, you are putting that onus on your colleagues in the court. There are circumstances when you should recuse and take yourself off the case, and that is when your impartiality might reasonably be questioned. This is an objective standard where a reasonable observer would decide that you should not be hearing this case. Under those circumstances, you do not need a formal motion to disqualify you from the case. The rules list the various bases upon which you should recuse yourself, and that is when you have a personal bias or prejudice concerning a party or a lawyer, when you have personal knowledge of the facts, when you've made a public statement about the case in which your objectivity would be called into question, when you previously served as a lawyer in the matter, when you previously served in the government, such as a prosecutor or public defender, and you were personally and substantially involved in that matter before taking the bench, when you might be a material witness in the matter, or you presided over the matter as a judge in another court. So, for example, you cannot sit as your own appellate judge when you made the decision in a lower court. There are circumstances also when the parties may agree to have you hear the case, even though there is a potential conflict, and they agree in writing or on the record to have you recuse. You must disclose the basis for the recusal, and the parties must agree that they are waiving the recusal under those circumstances. You should always disclose, even if you think it's not a basis for recusal, so long as it is relevant to a question of whether you can be objective or fair. You should disclose any potential conflict that you think the parties or the attorneys might want to know about. When I get a case, what I do is I essentially triage them into 3 different areas. And I look at it and I decide, is there a basis for my mandatory recusal? An example of that would be if it were my best friend and I have lunch with him regularly, or if it is my campaign manager and someone who ran my campaign 2 or 3 years ago. I think under those circumstances, anyone objectively would say that I cannot be fair and impartial to both sides. Then there's the second category. That's where I think I can be fair and impartial, but an objective observer might think I shouldn't hear that case. That's the one where I would get buy-off or agreement of the parties. An example of that would be, I teach at Seattle University. As adjunct faculty there, if Seattle University Law School or even the university were a party, that might be a situation where an objective observer might question my impartiality. I would disclose that to the parties and to counsel, and if they agreed to have me hear the case, then I would go ahead and hear it. If University of Washington Medical Center were a party to litigation, that's where I happen to have my treating physician. Again, I would disclose that. I would offer to recuse if the parties wanted me to, and I would then recuse if they requested it, or if they agreed that I did not need to recuse, then I would stay on the case. The third bucket I use is simply disclosure, where I think I could be objectively fair and no objective observer would likely ask me to recuse. An example of that would be where the Bank of America is collecting on a debt. I happen to bank at the Bank of America. I don't think that there's any significant conflict there, but that's something the parties might want to know about. So those are the 3 buckets that I put it into in my triage process in determining, do I have a conflict? What degree of disclosure should I make? There are other areas of Canon 2 that you should be aware of. I'll go over those briefly. You should not commend or criticize jurors for their verdict. You can simply thank them for having served as jurors. You will often get questions such as, do you think we reached the right verdict? And your only response should be that we think that you have fulfilled your duties as jurors, and as judges, we greatly appreciate your service. You should not make any public statements about a pending or an impending matter that could impair the fairness of that matter, or any non-public statements that could substantially interfere with that hearing. You cannot make any pledges or promises on issues likely to come before you as a court. If you do get inquiries about a case or about an issue, what is the best way to handle it? Well, while the case is ongoing, generally speaking, you shouldn't. The best thing you can do is, if you think a response needs to be made, is to either have the presiding judge speak on your behalf, contact our fire brigade, who is specially put up to discuss those types of issues, or our PIO, Public Information Officer, who can respond on your behalf. But generally speaking, a judge should not get embroiled in any discussion about a decision that he or she has made or about a pending matter. The rules require that the judge takes certain action if the judge knows that a lawyer or other judge is impaired. The judge shall, means required to take appropriate action, which usually means bring it to the attention of the presiding judge, the State Bar Association, or the Commission on Judicial Conduct. If the judge believes that a lawyer or a judge has violated either the RPCs or the CJCs, a judge is encouraged to take appropriate action, but not required to do so. If a judge is contacted by the Commission on Judicial Conduct, the judge must cooperate with the Commission, and in any investigations cannot retaliate against anyone who is assisting in an ethics investigation. Please be aware of the Caperton case that talks about recusal or disqualification when there's been a substantial campaign contribution made to your campaign. So now we're going to talk about Canon 3. Canon 3 addresses conduct generally outside of the courtroom. So Canon 2 focuses largely on conduct inside the courtroom. Canon 3 focuses primarily on conduct outside the courtroom. There's somewhat of a contradiction in being the role of an elected official as a judge. On the one hand, we're supposed to be the public face of the court, go out in the community, and on the other hand, we have restrictions on what we can do and say when we're in those community or public settings. And what the rule provides is that although we're encouraged to engage in extrajudicial activities, we have to do so within the context of what the code allows. And while engaging in those extrajudicial activities, we should not engage in activities that will interfere with the proper performance of the judge's judicial duties. So what that means is, if you can't be involved in even volunteer activities that will require so much of your time that you won't be available as a judge on the bench. You can also not get involved in organizations that require your frequent disqualification. So, for example, if you were to be involved in an organization that is with gun rights, one way or the other, pro-guns or anti-guns, so many of our cases involve use of firearms that could potentially require your disqualification. Also, activities that would undermine your independence, integrity, or impartiality. Again, if you were involved in organizations such as Mothers Against Drunk Driving, many issues involving alcohol come up in our courtrooms, and that might bring into question your impartiality on an issue involving alcohol and certainly involving drunk driving. Engaging in conduct that would be coercive, that typically comes up in terms of soliciting campaign contributions, which is expressly prohibited under other provisions of the code. And we already talked about abusing the prestige of the office through the extrajudicial or personal use of court premises, staff, stationery, etc., except for incidental use permitted by law. So many judges will allow use of their courtroom for high school mock trial competition, and that is permitted. Obviously, discriminatory actions and expressions of bias or prejudice by a judge, even outside of the courtroom, is going to call into question the judge's integrity and impartiality. If a judge were to belong to an organization such as the American Nazi Party, Ku Klux Klan, or some other organization such as that, it would certainly call into question the judge's independence or impartiality. Judges don't give up their personal lives when they take the bench, and so we all want to be appreciated and respected, and you're not going to get there by telling bad jokes or improper jokes. Under Rule 3.7, we are allowed to participate in educational, religious, charitable, and other type of civic organizations, and that is expressly allowed whether those organizations concern the law, the legal system, or administration of justice, or other types of civic organizations. However, even for law-related organizations, a judge should consider whether the involvement with that organization could possibly reflect upon that judge's independence, integrity, and impartiality. For example, there are some law organizations that take a particular bent. There is the Washington Defense Trial Lawyers, or the Washington Society for Advancement of Justice, WSAJ and WDTL. Either of those organizations would probably be improper for a judge to be directly associated with as a member. That said, you can attend their events on a social basis. Because Lambda Legal advocates, I do not think it's appropriate for judges to attend their events. There was one ethics advisor opinion that came out that said that judges could attend an NAACP luncheon. However, it was not a fundraiser, and because Lambda Legal does do fundraising, the judge might be able to attend, but should not contribute to that organization. So let's talk about other information about Canon 3, but there's not a lot of time to do that. So again, be circumspect about what civic and charitable activities you get involved in. You should not be involved in financial dealings which reflect adversely on your impartiality or which could interfere with your duties. Do not enter into business transactions or dealings with attorneys who might appear before you, and you may not serve as an officer, manager, director, or employee for any business except for family businesses. Canon 4 talks about judicial and political speech, again, what we can say inside and outside the courtroom. If you are a candidate for judicial office, you cannot engage in political or campaign activity, again, which is inconsistent with a reflection on your independence, integrity, or impartiality. So, for example of that, you cannot make a pledge, promise, or commitment which is inconsistent with your impartial performance of your adjudicative duty as a judge. So there was the Republican Party versus White, which said that struck down a Minnesota provision which prohibited judges from expressing their views on matters that might come before the court. The prior code in Washington said that judges could not appear to commit to particular political or other legal positions, and now the judges are prohibited from making pledges, promises, or commitments. What would that be? That would be making a stand either while you're a judge or a candidate for judicial office, saying that I believe in law and order, I'm going to be really hard on all criminal defendants. That would be making a commitment that I will give the stiffest sentence for any defendant who was caught with a gun. That would be making a pledge that you do not believe that drug laws are fair and that you would impose the lowest penalty on any offender that came before you for a drug crime. Those are the types of pledges and promises and commitments that do not reflect on impartiality or independence of the court. What we're required to do is look at each case on the facts and the law that applies to that case, and then make a decision, not make pledges or commitments in advance. In addition, we can't use court personnel for campaign activities. We cannot personally solicit campaign funds, although you may solicit endorsements. You cannot affiliate yourself with any party, whether that be Democratic, Republican, or Socialist, except for purposes required for the voting purpose or for showing up at a political caucus. You can also, in your campaigns, you cannot make false or misleading statements. Remember, you are responsible for those over whom you have supervisory responsibilities on your campaign and in your courtroom. So key factors in determining whether or not speech or activity is permissible is determining whether or not that reflects on the judge's impartiality, whether it involves impermissible fundraising, such as the judge soliciting campaign contributions, whether the speech abuses the prestige of the office to advance your personal interest or private interest, whether you are engaged in activity or belong to a discriminatory organization, whether your speech is political in nature, whether it is permitted speech in the context of a judicial candidacy, whether it promotes or diminishes public confidence in the judiciary. As indicated, you cannot personally accept campaign contributions. You should set up a committee to do that. You are responsible for filling in your public disclosure commission reports accurately and certifying the information in there is true. So, in terms of takeaways, the most important things to remember are you're a judge, 24 hours, 7 days a week. If you have a question about how would this look, think about the front page test. If you're engaging in conduct that you're not sure whether you should or shouldn't do, if your local newspaper is going to publish your name with that conduct and you don't think that looks good, you probably shouldn't be engaging in that activity. And finally, you have lots of resources available. Look over the Code on Judicial Conduct. There are published ethics advisory opinions that are available on the Administrative Officer of the Court's AOC website. You can also contact the Ethics Advisory Committee for advice. You can get either an informal or formal opinion from that committee. And lastly, there are precedent cases from the Commission on Judicial Conduct in which judges have been disciplined previously, and you can see what type of conduct is permitted under the code. That's it.